So we're on our last lecture day. We're bringing it all together today, hopefully answering everybody's questions, laying out the last we have to say about remedies, and a course that, quite frankly, as somebody put it in their mid-semester review, it seems like we're just talking about problems. It seems like it's just a list of things that have gone wrong. And at the end of the course, we'd like to both say that there are things we can try that haven't been tried yet, appropriate for a lot of these different situations, things that might work in some instances, be extrapolated to other instances. And I'm going to begin by filling out, put one more item on Larry's list that he concocted for us the other day. One more generic remedy that I think could be used across different institutions. But then in the second half of today's course, I want to think more broadly about questions that deal with the moral foundations of institutions, about what, if any, implication individual responsibility, individual moral convictions have on the way institutions perform, and how those themselves, those issues themselves, might be tools and leverage for remedies against institutional corruption. So I'd like you to conceive as maybe a first step in this last remedy in thinking about what it might consist of. You're all doing projects where you're trying to establish a case of institutional corruption out in the world. And you could imagine as one sort of remedy that we simply have a court presided over people like Larry or other judicial experts that say, bring to us, real live cases, well-documented instances of something that going wrong with an institution, and you'll lay out the evidence, we'll adjudicate it, and we'll decide if something's wrong, we'll step in and fix it. If some things are okay, we'll keep going. There were at least some people who proposed small ideas like this in some of their second papers. So is this a viable option? What sort of problems might this run into? What sort of solutions might it be good for? If we think we can diagnose institutional corruption, we just bring it to a public body that has authority to resolve these things on a case-by-case basis.
For starters, who would bring a complaint to the court?
Okay, so this question of standing. So who has authority? Would you have to be someone harmed by this institution? Could you be someone inside it? Could it be any citizen? This is a major issue in a lot of legal things, so it's not clear about standing. Okay, yes?
Well, it seems like the idea of doing it on a case-by-case basis is sort of antithetical to institutional corruption. It's this deeply ingrained thing, so you won't get it all.
So the question is, what authority or power would the court have? So you can say you believe Larry's case about the way campaign finance works and its deep flaws. A court single-handedly wouldn't probably have constitutional authority over change that. Maybe the Supreme Court, and that may be the closest thing we have, an analogy here, but it's not so clear there are levers of power that a court can pull if you believe that a case is actually compelling.
The question you asked in the beginning of the course, who got the arguments?
So there's a question about the composition. So how do we make that immune? Because surely this would be, if it's that powerful, if it has a lot of authority, it's going to be, people are going to try to control it for the same reasons that they would try to control any other powerful social body. Yes?
Specifying on that, how do you select the people?
Okay, so in selection, you want independence.
How do you prioritize all the cases that
Okay, so you might have a waiting list. You'll have to do prioritize that. You must think there's a lot of institutional corruption around. There's going to be a lot of that going on. Yeah.
How do you enforce any decision?
So you might think that they have the police powers of the state, that they can go collect taxes, impound vehicles, erect also, that men with guns show up and could conceivably enforce this like they do any other legal decision. Going back to McCain and who was that at the beginning? McCain and McConnell at the beginning of the semester. What might their concerns be? Trying to adjudicate this in a legal setting.
McConnell would definitely claim that
Why? Why? Exactly, why?
Institutional, so that your issues are with the system itself, not with any one person.
Not only one person, but what else? What else did he say? It's systematic, and McConnell had a few points. He said things like, have any laws been broken? Did I break any laws? So precisely the systematic nature that a lot of what we've talked about, the way in which economies of influence worked, it's not clear that these are always legal problems, although we've come across some cases that do look like clear fraud, look like conflicts of interest that there might be disclosure requirements for. So one question is where there's actually a legal frame, that is, are there actually laws that are being violated in the context of a lot of institutional corruption cases? What else? What's a problem you all are having doing your final projects?
Identifying true north.
Okay, so you can have a hard, this case of true north. This is going to be a difficult argument. What are the standards of evidence for that? How does that get explained? What's the barriers to proving that?
Identifying what deviation exists as the result of some influence.
Yeah.
Just because the compass is off doesn't mean there's necessarily a magnet there.
Yes. So this issue of actually, even say you know what true north is, making the case, how do you get the information, the knowledge, connecting the dots, do the analysis to make this whole story come together? And there's a lot of institutions for which only specific people are going to have this sort of information and knowledge. So we've dealt with a lot of cases where we either have investigators who've worked on this for a long time, they're in the public eye, so a lot of investigative journalists have looked at it. There are things that we maybe have personal experience with, so we have some immediate sense of the injustice or the problems with it. This is a really big problem. It's a problem that actually pervades a lot of social thought. How do we get the right kind of information to the right sort of people? So we've talked about some of these standard concerns of how you litigate, but this issue of who has the requisite knowledge is so fundamental. In the economic realm, this is often a sort of prima facie reason for the way and the reason we actually delegate all sorts of organizational capacities to markets. Because in a complex world, in a complex economy, there are no centralized agencies or units that are going to have all the information available to make the right choices. You have regulators set up at certain gates to try to be gatekeepers. But as Friedrich Hayek famously argued in this paper that was instrumental in him receiving the Nobel Prize, the knowledge people have, the knowledge we need to make a lot of social institutions operate is dispersed knowledge. It's contained in individual people in individual locations, and there isn't some central repository. And it's a really difficult thing to know how do you get that knowledge from a regulatory, from an oversight perspective. We're having a big debate in the United States right now because one very premium source of knowledge concerns communications that go back and forth between people, and there's a big interest in counterterrorism efforts to have access to that. And we have, as we know from the NSA recently, massive surveillance on an enormous scale to try to catalog this knowledge, and questions about privacy, questions about abuse. In terms of the people who have access to knowledge, I want to suggest there's two groups that are going to be recurrently privileged in the knowledge they have. The first are those who are actually harmed. So some of you may be writing on or thinking about institutions that you had some run-in the past, and you said, this shouldn't be working this way, this is corrupt. And you're going to have knowledge precisely because of that harm. Others are going to have knowledge simply because they're the insiders. They're the ones that operate the institutions. Let's think about first about those who are harmed and how they might be a vehicle for remedies. Anyone familiar with Coase's classic essay on the problem of social cost? So he begins this essay, this is again the essay for which he won a Nobel Prize, saying it's concerned with actions of business firms that have harmful effects on others. And he says a standard example is this polluting example. So you're going to put smoke in the atmosphere. And the question, the way in which it's usually been thought of is that we'll have regulators that penalize polluters. So we'll have some policy on air quality, and we'll say either you can't pollute over a certain amount or you need to pay taxes on a certain amount. But he suggests there's a different way, we might deal with this. He said, if people actually have a property in all these areas in which you might have others spewing externalities, then they can use that property right as a tort. They can use it as a way to litigate damages that they receive. So he classically talks about, say you have a farmer next to a cattle rancher. The cattle rancher keeps on adding more and more cattle to his farm. The farmer, meanwhile, is trying to grow wheat. And there's a question of how you're going to make these two neighbors not come into conflict. Either the cattle are going to graze on the wheat and cause the damage, or the farmer is going to have to put up a fence at his own expense to keep the cattle out. And Coase pointed out that as long as it's very clear who owns what land, what price cattle sell for, what price wheat sells for, there's an economically rational solution that these parties can come to, and they can litigate and say, if it's going to benefit the cattle grower more to have his cattle roaming around a little bit more, he can compensate the landowner, the farmer, to allow the cattle to go, because he's going to make a lot more money in the cattle. The farmer can make money losing a little bit of crop. Vice versa, if it's much more profitable to the farmer, he'll internalize the cost of the fence and keep the cattle grower out. So this is a maybe private remedy, and Coaseans think a lot about the way in which you assign property rights and you let tort law, through the adjudication of harms, be a way to discipline various sorts of actors. Now, what are the problems with that? You saw McIntyre raised a few reservations of tort law as a general approach to remedying institutional wrongs. You're satisfied, this works. Okay, yes?
So you can, from what I gathered, McIntyre's point was that you could structure institutions to be able to prevent institutional, there's a purpose for regulation, but ultimately it cannot take precedence over individual choice to do the right thing.
So McIntyre is very interested in this question of responsibility and how it is that moral commitments might actually inspire people to act in the right ways versus other domains in which law is much more adversarial. And he says something along the way. He briefly mentions Milton Friedman as a advocate of this sort of system. And he says, well, so one possible, let's think of some of our medical cases. I put out a drug, it kills some people, and their families seek redress. Is this a sufficient and adequate way of encouraging medical pharmaceutical companies not to?
Is that something that signals a breakdown in the physician-patient relationship? And that when you rely on laws, you sort of assume
Yes. So there's this one aspect of to what degree can law do a lot of this work for us? There's some more practical concerns. He says literally the litigants are going to be dead in a lot of these cases. So maybe your family can sue, but the actual harms that have been done are totally incommensurate. So this is a retrospective remedy. It's a way of trying to right something once a wrong has already been committed. And we might think that in terms of remedies, we're much more interested in trying to address wrongs before they happen. So I think as a remedial, as a second order remedy, it's good to have these in place, but they're not going to address, they're going to be retroactive rather than proactive. And the last thing Coase notes this in a kind of footnote, is that this assumes that it's costless to litigate these things. And it turns out lawyers' fees are extremely expensive. So torts are going to have some limits to them. But let's think about where another source of the knowledge of problems and how this might work prospectively. Those who are insiders. So the insiders are the ones that see on their everyday basis what corners are being cut, what exceptions are being made, what compromises are being done, what some of the activities of the firm are. Again, they might be dispersed in various ways. But they're precisely the ones, because they're embedded in an institution, that don't have an interest in defecting, in tattling, in causing problems. And so one question is, how might you get these people with the most intimate insider knowledge to be a source of change in institutional corruption? And this is the concept I want to add to Larry's list, which is this concept of whistleblowers, as one more practical example. So whistleblowing, this is what you get on the Office of General Counsel. If you work in DC, they'll tell you you can disclose information that relates to a violation of a law, a gross mismanagement, waste of funds, abuse of authority, dangers to public health, dangers to public safety. So it goes beyond just legal requirements, legal harms. You can report a wide variety of things. And what whistleblower laws and protections do is they try to give two sorts of incentives. One are reward incentives. The other ones are immunity incentives. The first of these, there were actually some in the Continental Congress during the Revolutionary War. This first gets sort of massively codified in U.S. law around 1863. In the context of the Civil War, they're extremely worried about fraud, people putting sawdust in gunpowder and that sort of thing. And you have these twofold protections. It says that the government actually takes this information you provided them and has a lawsuit and settles it, you get a % of the proceeds. And if you bring this information to light, you can't be fired from your job, you can't be dismissed, you can't be prosecuted by those who you work with and that sort of thing. So what do you think about this? What are its problems? It's a bit more, it gives more of an incentive, say, than having to litigate past harms. You can have insiders watching this, monitoring this, with huge incentives. What might be some other barriers to this working effectively?
For example, there's always a dodgeball, you don't get fired from your job, but you mysteriously, your car has a fuel leak.
Okay, so reprisals you think are something you can't really rule out. It's very difficult to rule out reprisals. Either that or you'd have to have really massive benefits, compensation for this to really be on balance, weighed out in cost of benefits.
It's all very well if you like blow the whistle on some peripheral subcontractor, but like if you're deep within the institution, like there's no guarantee.
Yeah. So there have been reports that Snowden, for example, tried some gentle whistleblowing, that is talking to his superiors or filing some small internal complaints. But at a certain point where those could easily be swallowed up by the bureaucracy, and if you're in too deep, you could be in a lot of trouble. So this promise might also be as in another way of being inadequate to the kind of deep knowledge and insider position you might be in. So a peculiar feature, in addition to these sort of indeterminacies of a lot of whistleblower laws, is you actually have to file a lawsuit. Like you, individual citizen, need to go forward and get an attorney, pay the filing fees, assemble something, file it under, there's a specific sort of secretive way of filing this, and then you alert the Justice Department, say, I filed this lawsuit, here's the evidence, would you like to join me, Justice Department? Justice Department can say yes or no. It's a very long, drawn-out process, extremely expensive for those people who go into it. And again, to make this in your interest, you really need to have the rewards be extraordinary. What's changed very recently, and this is maybe a reason for promise and a reason why this sort of concept might be more promising to address institutional corruption, is trying to turn the process of whistleblowing into a more administrative process, something that's anonymous to the right parties and that only involves filing a claim rather than filing a lawsuit. So and recently in Dodd-Frank, they changed they changed a number of clauses to enable you to do things that you traditionally required a lawsuit. You can now simply go on the SEC's website, download a form, fill it out, and say, I think there's insider trading at this company, here's some evidence to it, and submit it. IRS does a similar thing, and this has dramatically lowered the cost of doing this. It also, as a consequence of Dodd-Frank, set up this whistleblowing office under OSHA, which we heard about in Paul Romer's talk, we'll get to in a moment. And they try to give a systematic place of if you have any questions about whistleblowing, you go to this website and it walks you through how to do everything. Here's one of the forms. If you know any tax fraud in the United States, you can fill this out. It's only 2 pages. Provide whatever other evidence you have. And there's been a proliferation of these sorts of incentives that try to take people from the inside, offer them large rewards. Now you get 15 to 30% of the damages or the cost recouped under the IRS program and the Dodd-Frank program, and that can be pretty substantive. So people have begun, they've just had the first of these starting to come through administrative approval. There was a UBS employee who just made himself $104 million by reporting some tax fraud he saw while working at UBS. A number of states are thinking of incorporating whistleblower laws within their state governments, and you have corporations that are doing the same thing. They say, we have an enormous corporation, how do we know that our subsidiaries are acting well? And they're looking at structuring whistleblower incentives to encourage this sort of disclosure and recompense. And this has the nice consequence that you don't even need to be in the institution in some of these cases. If you're a good investigator, you can actually file these claims. You don't need to have any material standing within the initial parties that are involved in these institutions. And you might think of this as a way to crowdsource fraud detection. So you get a central beacon that says, here's an enormous pot of money that we're going to give to anybody who proves that something's going wrong with an institution. If you find yourself on the buy side of securities analysts anytime soon, you see something sketchy in a company's SEC filings, you might just file one of these and alert the regulators and find out 2 or 3 years later that your claim's been processed and you win, the $10 million settlement and whatnot. So this could be a very attractive way of realigning incentives to try to get insiders within institutions to divulge the kind of information that we think has been harmful, the kind of processes that we think are corrupting institutions. Any final thoughts and verdicts on whistleblowers? You actually can do this. Like if you're good researchers, this is a big opportunity. It's 2 years old. If you're convinced institutional corruption is a problem and you have a great case study, you might want to look into this. Any other limits, problems? Yes.
It doesn't always address that legal issue. It seems like all these cases you have to
Yep.
something that's actually illegal.
So this still requires some framework of either legal responsibility or some other, say, weaker sort of fiduciary responsibility that you have some claim to say there's been a gross abuse either within the government of certain legislative mandates or outside of the government of various legal things. So it's going to leave an enormous amount of stuff we've talked about that isn't illegal, perhaps out of this picture. And I think it's good to, yes, be reminded of that. Okay, so we'll add that to our little list of remedies. And two themes I think come out so far of these discussions is we're looking for ways to realign incentives, and we're also thinking strategically about how you might control information, particularly in blinding, particularly in eliciting information from those on the inside. And we might say for a wish list, how do these look to you in terms of principles for organizing institutions in a society? And then I'm going to ask you about whether there are principles, good principles for other areas too. But any objections to this list? Okay. This is good. So right now, there should be on its way a quiz to reward everybody who showed up today and to also help us think about another sort of remedy. Okay, it's on its way. As the first person to see it, let me know, raise your hand. Is there anybody who doesn't have a computer or a smartphone? Either devices. Okay, there's a few computers reserved right around there's a little computer lab right over there. I can help you negotiate and get on that. The good news is it's a very short quiz. You'll need, one of the answers, in case you need it, is, you see, that's the 10th question. And as you'll see, this is serving a variety of pedagogical purposes. But it'll be very easy for those that looked at the reading, and it'll help you to have shown up too. Just showed up? Okay, great. As you see, the questions are timed, so once you start it, you'll be on the thing. You can use your your name and email to begin. If there's any problems, raise your hand and stuff. We thought about playing the Jeopardy theme song. And you want to, yeah, I can bring you around. Okay, yeah. Okay, no, I won't. That's just cruel. Okay. Hold on, let me make sure What's that? Nope. Sorry, readings are off limits. And it's time, so it'll be hard to use the readings anyway. Good question. Let me go make sure that she's situated here. Okay.
Can we go back to a question?
Nope.
Okay.
I think literally the software won't let you, but
Not yet.
that was also by design. Starting to come in. Great, yes, they're rolling in. It's the same quiz, yeah. And in case anybody had any trouble, I was going to put that up there. Yeah, they're about half in. What do you think the people are thinking who aren't here right now? They could be filling it out, but
Did when you in class did text the last question?
yeah, that's right, yeah. I made it so that they could guess it if they want. But.
Are TS also receiving the quiz?
The TS probably were able to look at it. Did you get the email? I don't know if you're on the class list that I sent. Yeah, I think they weren't on the class mailing. I don't want to spam them with the. They'll see the answers, and this could be a valuable teaching moment in preparation for our last discussions, which are happening over the next few days. Yeah, so of course we won't have our sections next week. They'll just have today, tomorrow's, and people on Monday. And in the original email that didn't go out, unfortunately, because it wasn't queued up correctly, it notes that we'd love to have a full attendance next week, and that we want to have a full audience for everybody present their videos. I think that'll be great. We're going to try to get some snacks for the second meeting. Larry's going to end next Thursday with his own sort of impassioned summary in the final 10 minutes. We should have enough time to get at least through 30 videos, 15 on Tuesday, 15 on Thursday. At this point, is anyone still taking the quiz in the room? Okay, so everyone's figured that out. Okay, well, how'd you do? Is it fair quiz? Yeah. Yeah, why is it okay? You think, let's say in the first was it appropriate to give this quiz?
Yes.
Yeah, no, who said no? Okay.
It says so in the syllabus.
There's explicit rules, explicit incentives on the syllabus, transparent.
I'd say it depends on the strength of our ethic against cheating.
Aha, okay. Say more, explain.
As in, if we were all very confident that no one would be leaping through the readings while doing the quiz,
Yep.
then it would be, I think, an adequate assessment of how well
Okay.
we were actually prepared.
So as a assessment strategy, you
Yes.
think it's decent as long as you're pretty sure nobody's leaping.
Yeah. Otherwise, as a signal of you should do the readings for the class, I think it works. But as an assessment strategy that factors into our grade, it's
Right. So, and as a signaling strategy, we should have done it a few weeks ago, because
Yes.
that would have been, that would have gotten you to start doing the reading. So it's probably an ineffective for a lot of the, at least half the reason you'd give quiz is try to get people prospectively to prepare. So giving it now at the end of the semester is kind of a jackass move. So what else? I mean, what else? Is it appropriate though? I mean, so is it fair? Somebody else said, is it unfair? There was somebody doubted that over here. Yes.
So it's possible that we were all planning to do reads after the lecture, because we wanted to hear what you had to say
Yeah.
first. So,
So that's fair. And you fill out the survey at the beginning of the semester, where I think I didn't actually look at the numbers, but I can look at the charts and stuff. And it just says like 90% of people do the readings before class, I think, as they reported at the beginning of the semester. So I don't doubt that everyone in the class, I think both came into the school year, saying, and the class, I'm going to do readings. I'm a good student. I like to do readings. And certainly, it makes sense for us on the syllabus to say readings are important and to incentivize these in various ways. You had another comment?
Oh, I was thinking because perhaps it's like a one-time assessment. So for
Mhm.
example, around this time slot, there are a lot of other final projects that are going on. So that means that a lot of times it might not necessarily be a fair assessment of what students have been doing for the
Yeah, no, this is a terribly disrespectful thing at the end of the semester. You all are really busy preparing for all your final projects and papers. And here we are going against what's kind of been an unwritten norm in the rest of the class, which is, show up, you can watch the lectures, you can listen to the lectures. But we're sort of, you might say, violating an existing, maybe it wasn't a formal norm on the syllabus, but we're violating norms that people had come to expect, and that it might even be reasonable to expect in the last week because you're all busy. And what is our purpose? It can't be to incentivize your readings. We're doing it at the end of the semester. Do we really care that much about assessing this one particular set of readings?
The sections depend on our being prepared, but there are no sections that meet to date. So the earliest that
There are. Okay.
Monday section, but
Right, yes, no, that makes sense. Yeah, so that is confusing because we have the weekend thing.
Who have kidding.
Yes, no, but and this is part of the earlier explanation that everyone was going to do them before section, but for lecture you might not need them, even though it was a little explicit thing on the syllabus. You might think, so you might think this is disrespectful. It's a violation of certain norms. The questions themselves might have been fair enough, but the timing of it might have been unfair. The one thing I think this helps us think about, and it's something I was talking with Chris Winship, who's a sociologist here the other day. He has a similar class that he looks at institutional failures. And he noted in our syllabus that we haven't talked a lot about a lot of the sociological realities that defined organizational context, institutional context, and how those dramatically generate economies of influence on their own. So if you talk to you can talk to a lot of people who look at organizations and their dysfunction. Oftentimes cheating when it's done in organizations, compromise when they're done in organizations, people will say, look, I had been screwed over last quarter, and this is my way to make up. Or they say, look, my boss was an idiot. He hadn't respected me. I was entitled to a little bit of slack. People talk about the cycles of vindictiveness that happen within organizations. They'll talk about not feeling appreciated. This issue of moral licensing comes up. I don't know if you thought there, boy, it's unfair for him to send this quiz out right now. I'm just going to peek a little, I'm not a cheater, but I would just peek a little bit at a reading because it's an unreasonable expectation in this circumstance at this time of the semester to have sent a quiz out like this. And I think there's something to that. You might say, if I've been slighted in some way, this licenses me. Or if I've been particularly exemplary all semester, I've done all the reading so far, today's the only day I missed, surely I can, cut a corner just today. There's an enormous amount of research on moral licensing, on some of the sociological effects of these processes within organizational contexts. I'm not going to give you the full sociology review or the psychology review. There's, I think this is put more succinctly, so Auden has this great poem on September 1st, 1939. This is the beginning of World War II, essentially. He's in New York. I sit on one of the dives of 52nd Street, uncertain and afraid of the clever hopes expire of a low and dishonest decade. Waves of anger and fear circulate over the bright and darkened lands of the earth, obsessing our private lives. The unmentionable odor of death offends the September night. And in the second stanza, accurate scholarship can unearth the whole offense from Luther until now that has driven a culture mad. Find what occurred at Linz. Linz is a site of both Catholic Protestant cycles of violence and reprisal, as well as a birthplace of Hitler. What a huge imago made a psychopathic God. I and the public know what all school children learn. Those to whom evil is done do evil in return. So partly a reflection on what are some of the cycles of violence, of retribution, of willingness to engage in bad behavior that are not necessarily written into the formal rules of an institution, but due very much to the interpersonal dynamics of having to deal with other people, their disputes, their priorities, their character. The sociology of organizations is something we're studying for people who are going into or thinking about very specific analysis of firms. We have two people associated with our lab at the Ethics Center who deal with questions of dignity, compromise, how these things work systematically within various sorts of environments. It could be business environments, government environments. Elizabeth Doty in particular and Donna Hicks have called attention to how violations of these norms really affect people. People aren't willing to be team players anymore if they feel like they haven't been respected as persons. And respecting people as persons then might be one sort of additional remedy, one sort of thing we might put on our list. But this really opens the door to, I think, a much wider set of questions about the kind of character, the kind of responsibility, the kind of personal relationships, the kind of commitments that people have within organizations, within institutions, and what influence we can have over those. So that brings us to the Lyceum Address. Abraham Lincoln gives this in 1838. The Young Men's Lyceum in Springfield. That puts Lincoln, how old is Lincoln at that time? Your estimates?
28.
Yes, 28, 29, he's right in there, yes. So he's writing this in his 20s, and what's the subject of it? The perpetuation of our political institutions. Yes. This is a subject selected. So what's his explanation for why American political institutions had succeeded? By the way, so we can make a deal. I wanted to put that quiz out there as like a norm violation thing. We'll talk about that. If everyone shows up next week, we can do one of two things. We can either, if everyone shows up next week, forget this quiz, or if only half the class shows up next week, we'll just give a quiz in that class rather than this class. It'll be a general type of quiz and things. Most of you we will very much reward people for showing up. So yes, these results, although I think we're going to find them humorous when we look at them, the course staff, they will not count against your final grade. But hopefully these last slides will help illuminate any questions that you did get wrong, and we can think systematically about their implications for deeper moral, cultural issues in the relationship to institutional performance. So why has America succeeded in his count? What are some of the crucial pillars that he says are now crumbling around America in the 1830s? It's an interesting thesis about what held it together in the founding generation, yeah.
In general, it was like him doubting about mob rule and that there was this disrespect for law and order, and that when people feel like they can take law and order into their own hands, even if they feel like they're justified in those actions, it leads to tearing down the political institutions and destroying the country in the long run. Excellent.
Wonderful summary of exactly this. So he begins with mob rule. Law is disrespected. If people ultimately don't respect the law, the Constitution, the political institutions of the land, their allegiances will no longer help them function. And we could think about the American project failing, not because he says there's an external aggressor, but because people fail internally to continue to, on their own sort of, moral accord, align and think the principles of this country are important, the principles of the rule of law, the actual institution set up to adjudicate that. He has an interesting sort of sociological observation too, of why is it that people have had such an allegiance to law and to the American project in those first So we had a common enemy. So exactly. So there's this one, very immediate human dynamic, which is, I think, mimicked in a lot of other environments. Say you're a startup company, or you're a sports team, or you have a common enemy that brings you together. So this could be a force for all sorts of cohesions that we think are important. And along that same line, yeah.
It's a living history with most families having sacrificed.
Yeah, so you see your grandparents, your uncles, your fathers, they have scars, they have limbs missing. There's this very immediate sense that there's a price that was paid. And then look, we're all in this together, and if we fail, it's enormous embarrassment. We've pledged our lives, our fortunes, our sacred honor. By Lincoln's telling, it matters an enormous amount for the perpetuation of political institutions that people have this buy-in, and a lot of the buy-in that naturally comes from championing a cause is going to be lost in the second, third generation. You no longer have that immediate connection. So that's why they were in trouble. That's why they succeeded. So what's the solution for Lincoln? How does he approach this? He has a very specific solution, although perhaps far-fetched. So he has a sort of striking paragraph. The question recurs, how should we fortify against it? The answer is simple. Let every American, let every lover of liberty, every well-wisher of his posterity swear by the blood of the revolution. This is really dramatic. Never to violate in the least particular the laws of the country, never to tolerate their violation, as patriots of '76 did, so to the support of the Declaration of Independence, so to the support of the constitutional laws, that every American pledges life, his property, his sacred honor. Let everyone remember that to violate the laws, to trample on the blood of his father, to tear down the character of his own, to his children's liberty. Let reverence for the laws be breathed by every American mother to the lisping babe that prattles on her lap. Let it be taught in schools and seminaries and colleges. Let it be written in primer spelling books and almanacs. Let it be preached from the pulpit, proclaimed in legislative halls and enforced in courts of justice. And in short, let it become the political religion of the nation, and let old and young, rich and poor, the grave and gay, of all sexes and tongues, conditions, sacrifice on its altars. So this interesting notion of a political religion, and he's an originary person to use that phrase in this sort of context, to say we need something that binds people to an institution because of this a moral commitment and belief in the sanctity and purpose that it's dedicated to. What do you think about this? One, is he right? This is important. Second of all, is this something that we can affect?
Well, it sounds slightly like, let's stop problem X by making people not want to contribute to problem X, which just seems a bit circular.
Mm-hmm.
And of course, it does get to the problem of how can cultures be established and how can they be maintained, because it doesn't really go into that.
Yes. Well, there's some very specific things, but like reading to the little babe on your lap. But yes, ambiguous. So, so would you say, as a principle, this may? I mean, in some sense, you're saying it's tautologically true what he's saying, but it's not like a real.
Viewed through one lens.
Yes. Okay. So you're.
Viewed uncharitably.
Yes. So you're not very optimistic about the insights that this sort of analysis brings to actually solving problems.
Isn't he essentially just saying we should commit to the spirit of the institution
Yeah.
rather than the letter of the law?
This is, yes, a very interesting observation. So you're familiar with the Gettysburg Address, right? Begins 7 years ago, our fathers brought forth this continent a new nation, conceived in liberty and dedicated the proposition that all men are created equal. So the interesting thing, so when most people say, when did America begin, right? What is the legal framework for America? This would be the Constitution. So Constitution, you might think of that as the letter of the law, and he talks very favorably about the Constitution here. But in that speech, so 7 years ago, it's delivered in 1863, 7 years ago is 87. Where is he dating the origin of America to? Declaration. And the Declaration isn't a legal document. It's not a legal framework for setting a government. It's a proclamation of ideas. So you might think of this as, yes, a call for the spirit of the law to guide people's allegiances, and that, in fact, that bears upon the interpretation of the law and its actual legal framework. Anything else to say about Lincoln beyond your, yes?
How do you strike the balance like too far to the side of being rigid and not questioning things as time goes on as
Yeah.
situations change?
It does create a problem in this unceasing reverence for the Constitution, which is itself amendable, of course, and changes and will change quite a bit. So I'm hearing a veiled critique of this might be sort of an ideological indoctrination that could be conservative in the worst sense, that is not allow people, and there might be a danger in general if we want to foment this sort of allegiance, and there's a whole history of sort of ideological education in the 20th century. This could be a difficult project, even though it might sociologically resonate as a genuine phenomenon.
I think from a rhetorical perspective also that it might not be that he's proposing this as an actual solution, but he's trying to like rile up the crowd and say,
Yep.
the American, and then both of me, of course.
Yes.
That'd be the American.
So this is definitely a piece of rhetoric. It's a piece of rhetoric we still read, and so it's accomplished that purpose. Another way of putting this, though, is you might say we might want to think very explicitly about how to articulate the moral purposes of institutions and make that intelligible to people in a way that they get excited about these purposes and want to be part of their solution, their better natures, rather than their worse natures. But a question I'd love to ask, what would McIntyre say about this? So what would our contemporary philosopher, Alistair McIntyre, what would his concerns be about the capacity of, say, moral allegiances to solve many problems of institutional performance, of institutional corruption? This goes back to, I think, some comments that were mentioned earlier.
Well, when you talk about it sort of from a regulation framework, it's almost the opposite, right? When you impose regulations on people, that's saying you don't have the ability to do it yourself, so we're going to do it for you. So it's almost an opposite stance. I know he sort of waffles on the regulation thing, but he says that's what we can do. That's, I feel like, the opposite perspective.
Yeah, so there's this idea from, I think McIntyre will agree wholeheartedly with Lincoln's perspective here, that it matters a great deal that, say, communal organizations, institutions have more purposes that people buy into. But the reality is in our world, we have a lot of institutions whose purposes are contested, we don't share a common framework about how people should act. We have a lot of, and he talks about these two cultures, one of which is very much thinking about the law as a device that helps us achieve common goods. The other is a law as a tool or framework for ensuring our interest or using it as a way to exploit others. He says these are two sort of rival ways of thinking about law, and it's generally the case, as in this quote, that he says when law really works, it's because people buy it, because people believe in it. But this precisely isn't the kind of law we need in a lot of regulatory contexts. We need it because people have reasons not to buy into it, either enormous incentives not to buy into it, or various conflicting beliefs about what it ought to be. So he'll reluctantly, his verdict on regulation is like Churchill's verdict on democracy. He says that it's the worst except for all the alternatives. He says there's a place for it, but there's an interesting twist in the end of his essay. So he talks about these sort of two concepts or frameworks of law. That certainly a lot of lawyers think of law like this. A lot of citizens, and we talk about democracy and legislation, we think of law in the first sense. And regulation is often going to try to deal with people who think of the law in this context. And absent wider moral agreements, that might be necessary. Is McIntyre, so just that one question, is he optimistic about the future of medicine? Does he think things are getting better or worse at the end of that essay? Anyone read to the end? It's just in that last paragraph. So he says, if you actually look at all the debates, and this is part of a larger debate where they cite a lot of medical cases of malfeasance and fraud and malpractice. He said there's a lot of reasons to believe that doctors no longer have the same moral relationships with their patients, and we've seen all these scandals. But he says, in fact, he thinks things are getting better, but we have no reason to think they would have gotten better given the existing incentive structure. In his account, though, the reasons they've gotten better is because everybody started talking about how bad they were. So that the very act of identifying this as a problem generated a public discourse that made people self-reflective, people who engage with these institutions either as doctors, providers, or as patients, a lot more cognizant, and that this very sort of notion of self-awareness and discourse has seemed to be a lever of reform on its own in the community. So he'll, even though he's quite pessimistic about whether incentives have changed, he sees a possibility for moral discourse to actually be a remedy, but it's not a very reliable remedy. It's something that kind of comes and goes. It depends on the quality of people's persuasion, the quality of the debates, the publicity surrounding it, the nature of education. He makes one final point in those sort of last paragraphs, which is there's another reason that we can't rely on morality always in organizational contexts, your personal commitments, because often you don't even know what you're doing. You're on one side of a company and you have no idea what bolt or widget you're putting together is going to finally be implicated in some other part of the company's final product. You have the people who are making decisions that he talks about in the phthalimide scandal. The doctors are actually, injecting people with drugs that will cause terrible disfigurements, are not the same people who are actually manufacturing drugs, and are not the same executives who are ordering the drug trials. And the people are, if you actually, probably took this executive and said, here's the disfigurement that this could possibly cause, will you do the injection? That might engage a sort of, moral hold or a moral reluctance on their part. But McIntyre suggests that organizations themselves, the corporate action itself obfuscates responsibility. So if we're thinking of also remedies, the capacities of moral commitments, sheer complexity of organizations is going to be an impediment. And that's where I want to bring us to Romer's very weird, bizarre, but interesting essay on Myron's Law. So what is Myron's Law? Stated abstractly or in general? Yes. Okay, we got to choose one of you.
Asymptotically, like finite tax code will produce zero revenue.
Brilliant. And what does that mean? What is his point?
In other words, like people will successively gain and like work around the tax code until ultimately, over time, they figure out how to get around every single provision because there are a finite number of provisions.
Yeah. So if law is then that second group, that if law is simply a way of pursuing interest, then pursuing my interest or protecting against others, the law, any specific law, any rule, will always eventually this is a thought experiment, but it could be open to all sorts of gaming, to ways of working around it, to redefining of other things that it supposedly regulates. So the larger question that Romer begins with, he asks, how must rules themselves evolve and change to keep pace with the kinds of problems that evolve and change? And what's one of the major sources of evolution, change, and new problems that he sort of cites? Just very generally, we'll talk about technology. So the very fact of, we're constantly getting new technologies, it's not clear what rules should govern them. He talks about high-frequency trading. He talks about the aeronautics industry. And how is it, as an intellectual exercise, how is it that we define a set of rules and enable those rules to change in a way that actually is conducive to the kind of public goods and purposes we think institutions should serve? So what does he identify as the sort of two alternative approaches to this? Yeah.
He compares, for example, the Federal Aviation Administration with OSHA.
Yes.
So that in one, which he talks, the Federal Aviation Administration, which governs a field that is very fast-moving, very constantly innovative, there are very few fixed rules, and then individual regulators have broad authority to make decisions based on their own consciences or their own thoughts, but they are personally responsible for those decisions. Whereas in OSHA, they've tried to make a very strict code of pretty very precise principles for how, for example, construction sites should be laid out. And then the role of regulators there is basically reduced to making sure those rules are mechanistically followed.
Yes. So you have this, on the one hand, OSHA's legalistic, process-oriented thing. We have, it regulates the height of a banner on stairs. And up till, I think it's 1994, the banner should be between, say, like 32 and 34 inches. However, after 1994, it should be no less than 36 inches. And he talks about the stopgap rules that make those consistent. It turns out any of these judgments can be litigated. So even though these rules were proposed in 94, they don't go into effect until 2005. You have this enormously long, drawn-out process, and it's a reasonable attempt to address the problems McIntyre raises. How do you get specific regulations that actually bind people to do things and enforce safety in ways that people might otherwise not do? But it seems like a terribly costly and cumbersome way to do it. Now, he contrasts that, as you say, with processes of responsibility that you might find in the FAA, in the Federal Aviation Administration. And so how does that work? What are some of the ingredients of responsibility within organizational context? You just tell everybody, be responsible. So he'll admit, that this needs to be thought out as well. There's a design to this. He talks a lot about the Army as well. He signals out. He says, look, you have very strict hierarchies. You have clear domains of accountability. So if you're a sergeant, you have certain people under your command. If something goes wrong under that command, you're the one held responsible. You have a chain of command above you. You're periodically reviewed. And at all those stages, you can't hide behind saying, I checked off all the rules. There's going to be a place for rules like that, I think Romer will still say. But the ultimate defense, the judgment's on you. So he's thinking organizationally, how is it that you carve out areas of responsibility where moral commitment can actually find its full license to actually express itself, as well as the kind of hierarchical structures that actually enforce this, can actually make people accountable. And the great virtues, of course, as is played off in this essay, of moral responsibility, of judgment against rules, is you can actually look at the facts of a case. You can make judgments where abstract general rules aren't going to be sensitive to the actual different complexities that are going to confront us continually with changing technologies, continually with hard cases. So we discussed some of the examples. And what Larry and I wanted to end on with this semester is thinking about the purposes of this course, where what we tried to introduce at the beginning was a sense of some of the theories that economists, that political scientists, that sociologists, to some degree psychologists, use to understand how organizations behave, how institutions behave, how they're structured, what are some of the levers of change. We then spent a lot of time on case studies, exposing you to examples of particular institutions that we all care about and how they've gone wrong and questions that arise in them. You all are out there on a hunt right now for your own cases, making your own investigations, connecting the dots. At the end of the day, it's probably well, we'll see. We'll see on Tuesday whether you've solved the world's problems. But this is in many ways an exploratory stage, an introductory stage. We don't expect anyone over the course of the next week to have solved the problem of conflicts of interest in medicine. We don't expect you to have figured out the way in which U.S. election system should be revised to balance special interest and moneyed interest off the will of the people and the proper avenues for representation, even if you're persuaded by Larry's position or any of the others we've read. I think these are good intellectual exercises, but the reality is, at this point, there are a lot of talk, and it may not change the world tomorrow with what we're doing in this class. But one of the larger pedagogical purposes of a class like this, I think, at an institution like this, is having thought both about institutional design and the incentives that are placed, but also about the moral commitments that structure and anchor those the kind of purposes we bring to institutional design, as well as the kind of responsibility that can define leaders who are going out in the world. Our hope is that people going through this institution become more aware of how all these other important institutions out in the world work, some of their liabilities, some of their dangers, some of their temptations, some of the mechanisms that might be used to improve or corrupt them. And then as you go into positions of responsibility, you may not be the new Lincoln. You may encounter McIntyre's problems about diverse moral conceptions. It may not be perfectly possible to delegate responsibility all the way down. You're going to need to devise rules. But hopefully you're in a position to better engage, interact with, run institutions like this, so that down the line, this mixture of incentives, moral commitment, responsibility is something that at least those in power, those who are shaping institutions, understand. Because ignorant of that, there's sort of no hope, but with some knowledge, you might actually begin to have some of the tools necessary to make changes that could be positive. And you yourselves might be a lever of change for institutional corruption. So that's the big picture, the end. Larry, as I said, wants to give a 10, 15-minute final talk on Thursday at the end of our presentations there. We're looking into popcorn for Thursday. It's the place in South Station that we wanted to get is closed down. So we might have another kind of snack. We're thinking cookies maybe. If anyone has ideas, let us see us after class. But you've gotten all the material we wanted to share. We're going to have hopefully a great video session Tuesday and Thursday. If anything's particularly good, we can go on and share them with other people. For those doing papers, we look forward to reading those as well. And yeah, Larry will finish this up on Thursday afternoon, but we look forward to seeing you next week, and best of luck with the final projects.